Thanks, Aldrin. Former President Jacob Zuma's legal team says they will not be challenging the warrant of arrest issued for their client. The warrant has been stayed until his next court appearance on the 6th of May. Pietermaritzburg High Court Judge Dhaya Pillay issued the order after the former president pulled a no-show due to ill health. Zuma and his co-accused, the French arms manufacturer Thales, are facing various charges including corruption, money laundering and racketeering. They relate to 780 questionable payments in connection with the controversial arms deal in the 1990s. We're joined now by Advocate Makhosazana Mbonani for more on this story. A very good evening to you, Advocate, and thank you so much for speaking to us. So, before his expected appearance in court on Tuesday, Zuma's lawyers had indicated that he would be unable to attend the hearing as he was receiving medical treatment overseas. However, the judge issued a warrant saying that there was not sufficient evidence given to prove that he was ill. What evidence would have sufficed in this case?
Thank you. Good evening, and thank you for having me. What is usually required in these circumstances is for the medical practitioner who issues the medical certificate to briefly canvass what the medical condition is, what the treatment required is, and how long it's expected to last. Basically, from what we saw today is that there was a medical certificate merely saying or explaining to the court that he would need treatments from this date and would not be available to appear in court today. And that was not sufficient evidence as per the court. And in any circumstance, whether it's at the magistrate's court or at the regional court, you have to canvass, and the medical practitioner can even depose to an affidavit canvassing and making it clear to the court that these are the circumstances and these are the reasons why the accused cannot appear.
And interesting observations made by the judge. One of the things that she said is that it seemed the document itself had been altered, the date thereof, but had not been initialed. And when written in terms of layman's diagnosis of what is wrong with him, it said medical condition, and was also suggested that the document was not signed by a doctor. These are very serious findings, don't you think?
Those are quite serious findings, but to deal with them each, the judge said that it appeared that there was an alteration in any documents, whether it's an affidavit or whether it's a certificate that is going to be used as evidence in court. If there is an alteration, there's a need for an initial and a signature to show that whoever was issuing that document is aware that there was an alteration and they still stand by the document. That is why the judge queried that there was an alteration and no initial or indication to the court that this document was still authentic. Second, there must be a date, because whether or not there's a stamp, an original stamp, there has to be a date to say when this document was issued, so that the court can satisfy itself that it was not issued maybe in 2017. And what we can take away from that is that even though the former president is being treated by the military medical personnel, and because the courts cannot understand some of the abbreviations or how it operates, it is the duty of counsel for the accused to ensure that the court is satisfied or the court is assisted to understand whatever evidence is placed before them. And I suppose those were the queries that the judge had.
Advocate, I want to talk about this. The judge also saying that what goes out in the public domain, in the media, and what is exchanged by counsel is not evidence. So does this imply that the judge felt that his being ill was public knowledge, therefore no effort was made to prove it, or she was ensuring that it is out there, that the judiciary is not influenced by what is within public domain?
That could be the case, but I suppose from the submissions of counsel for the prosecution as well for the state and counsel for the respondent, for the accused, the former president, there was a debate as to whether his privacy, and because it was critical that his privacy be protected in these proceedings, and that perhaps that was the reason why the counsel for, or the legal team for the accused did not furnish the prosecution with a medical certificate or medical reasons prior to today's hearing. So okay. I suppose that their thinking was that they should protect his privacy, and the judge was merely saying that evidence before the court is not for consumption of the public,
I need to ask
and
a
that
quick
it doesn't
question
excuse.
I need to ask a quick question before we go, and that is, the warrant has been stayed until May 6th. Does this dampen the effect of the warrant being issued?
The warrant is issued, but the fact that it stayed means that he will not be arrested, say, when he lands at OR or Durban International Airport. What will happen is that on the next occasion, he would have had to explain prior to or in consultation with the state why the warrant of arrest should not be executed against him. So he must give reasons why he should not be jailed pending the finalization of the matter. Advocate
Makhosazana Mbonani, thank you very much for your time speaking to us from our Durban studios.